situations. First, when it is literally impossible for a private party to comply with both federal and state laws simultaneously. If obeying one means violating the other, the state law must give way. Second, conflict preemption also occurs when a state or municipal law stands as an obstacle to the accomplishment and execution of the full purposes and objectives of federal law. Even if compliance with both isn't strictly impossible, if the state law frustrates the federal law's purpose or interferes with the means Congress chose to achieve its objectives, it can be preempted.
Okay. Impossible compliance or frustrating the federal purpose. So if federal law does not preempt state law, either expressly or implicitly, does that mean states are then free to regulate the same issue? Does federal law always set a maximum standard, a ceiling, or sometimes just a minimum floor?
That's a really helpful way to think about it for the exam. If federal law does not preempt state law, then a state is generally free to enact legislation regarding the same issue. Federal law often sets a floor, a minimum standard below which state law cannot go. Think workplace safety or environmental standards. But federal law does not necessarily set a ceiling, a maximum standard above which state law cannot go. States can often enact stricter regulations than federal law requires, as long as those stricter laws don't actually conflict with or frustrate the federal scheme. So, unless preempted, states often retain significant regulatory room. Relations among states, Chapter 9.
Moving to Chapter 9, Relations among States. This deals with how states manage their interactions, and crucially, how they respect each other's legal decisions. It's all about ensuring a unified nation despite having distinct state sovereignties. How do we make sure judgments in one state mean something in another?
That's right. The primary constitutional mechanism here is the full faith and credit clause found in Article 4. This clause essentially mandates that a court in one state must give full faith and credit, meaning recognize and enforce the public acts, records, and most importantly for the bar, the judicial proceedings, judgments of every other state. This is fundamental to ensuring that litigation doesn't simply start all over again every time parties cross state lines. It fosters legal predictability and cooperation among the states.
So if a judgment is rendered in, say, California, a court in Nevada can't just ignore it if the winner tries to enforce it there. What are the specific conditions for that recognition to be required? It's not automatic for every single court order, is it?
No, not every order. To trigger the full faith and credit clause and require an out-of-state judgment to be given effect, 3 specific conditions must be met regarding the original judgment. First, the court rendering the original judgment must have had proper jurisdiction, both personal jurisdiction over the parties involved and subject matter jurisdiction over the type of dispute. If the first court lacked jurisdiction, its judgment is void and gets no credit.
So jurisdiction is key.
Absolutely. Second, the judgment must have been on the merits, meaning it addressed the substantive elements of a claim or defense, rather than being merely a procedural dismissal, like dismissal for lack of venue or improper service. A judgment on the merits resolves the actual legal dispute. And third, the judgment must have been final, meaning it definitively settled the rights of the parties and disposed of all issues in the case, with no appeals still pending or further action required by the rendering court. If these 3 conditions, jurisdiction on the merits and finality, are met, the judgment is generally entitled to full faith and credit and must be enforced by other states, even if the enforcing state disagrees with the original outcome or the law applied. Ex-state action, Chapter 10.
Chapter 10 brings us to a really crucial concept that underpins many of our constitutional protections, especially individual rights. State action. The Constitution generally protects individuals from government conduct, not from purely private parties. So the big question is, when does seemingly private conduct become subject to constitutional scrutiny? When does a private actor have to follow the Constitution?
This is an absolutely foundational principle in constitutional law, and you must analyze it whenever a constitutional right is asserted against someone other than the government itself. State action, which encompasses actions by federal, state, and local governments, is a prerequisite to triggering most constitutional protections. Think about the Due Process Clause, the Equal Protection Clause, or the First Amendment. They generally protect individuals from government infringement, not from purely private behavior. For example, your private employer can often fire you for your political speech, but the government generally cannot without meeting constitutional standards.
Right, the Constitution limits the government, not your neighbor or your boss, usually.
However, there are specific scenarios where a private actor's conduct can be so intertwined with the government that it's deemed state action and thus subjected to constitutional scrutiny. The private actor essentially steps into the government's shoes.
So when does this state action occur for a private actor? What are the main tests the courts use?
There are two primary tests, or categories of situations, for when a private actor's conduct can be considered state action. The first is the traditional public function test. State action exists if a private person or entity carries on an activity that is traditionally performed exclusively by the state. The key words here are traditionally and exclusively.
Exclusively is a high bar.
It is. Classic examples include running primary elections, which is historically a core government function, or operating a company town where the private entity effectively steps into the shoes of the government in performing, essentially, all public services for the residents. It's a narrow category.
Okay. And the second test, often called the significant state involvement or entanglement test, that sounds broader.
The second category is significant state involvement entwinement. State action may exist if there are sufficient mutual contacts between the conduct of a private entity and the government, such that the government is pervasively entwined with the entity, or significantly encourages or facilitates the private action. This means the lines between public and private are blurred, and constitutional standards should apply to the private entity. This can occur if there's a mutual benefit, like a joint venture between the state and a private entity where they are essentially partners. Or if the state creates a private entity by special law specifically to further governmental objectives and retains permanent control of that entity. Or, importantly, if the state enforces or encourages the private discrimination.
So it's about the connection, the nexus between the state and the private action.
Right. This test looks for a deep enough nexus or a symbiotic relationship between the private actor and the government, or affirmative state encouragement of the specific conduct being challenged.
So if a state simply licenses or regulates a private business, like a bar or a restaurant, that's not enough to trigger state action if that business discriminates, is it? It seems like the government has to be more actively involved than just issuing a license.
That's a critical distinction to remember, and it's a common point of confusion on exams. Mere licensing or general regulation of a private party is almost never enough on its own to constitute state action. The state must do more. It must affirmatively facilitate, encourage, profit from, or authorize the specific discriminatory or challenged activity for it to be considered state action. It's not enough that the state permits the private activity to exist. It must be truly involved in or supportive of the specific unconstitutional conduct for the private actor to be treated as the state. Procedural due process, Chapter 11.
Let's move on to Chapter 11, procedural due process. This is about the fundamental fairness requirements, the procedures when the government tries to take away someone's life, liberty, or property. What kind of process is actually due before the government can do that?
Procedural due process is a cornerstone of fairness in our legal system. It ensures that necessary procedures, fair steps, are followed before any person, and this includes corporations and non-citizens within U.S. jurisdiction, can be deprived of life, liberty, or property by the government. It's important to note its dual applicability. The Due Process Clause of the Fifth Amendment applies to the federal government, while the Due Process Clause of the 14th Amendment applies to states and local governments.
Same concept. Different amendments applying to different levels of government.
Exactly. Also, crucial for analysis, procedural due process is only required when the government acts intentionally to deprive someone of one of these interests. It's not triggered by mere negligence, for example, if a government employee accidentally damages someone's property or causes an injury. There needs to be a deliberate government act causing the deprivation.
Okay, intentional government action. So the first step in any procedural due process analysis is always to identify if there's a protected interest at stake, life, liberty, or property. Can you elaborate on what exactly constitutes each of these, what qualifies?
Certainly. For life, it's quite literal. The government deprives a person of life, such as in cases involving the death penalty, obviously the highest stakes, requiring the most rigorous procedures.
Right.
Liberty is broader. It means the government significantly restrains a person's physical freedom, like incarceration or civil commitment to a mental institution, fundamental constitutional rights, like freedom of speech or religion, or freedom of choice in fundamental personal matters, like loss of parental rights or severe occupational restrictions that effectively prevent someone from pursuing their chosen profession.
So losing your job isn't always a liberty interest, but maybe losing your professional license could be.
It could be, if it's a severe enough restriction. Property is also broadly defined, but it's not just physical things. It's when the government deprives a benefit from a person who has a legitimate claim of entitlement to that benefit. This entitlement usually arises by virtue of a statute, a regulation, an employment contract, or some established custom.
A legitimate claim of entitlement, so not just a hope or expectation.
Exactly. Not just a unilateral expectation, but a reasonable, objective entitlement. Common examples include the loss of government-issued licenses, like a driver's license, the termination of government benefits, like welfare or disability payments once eligibility is established, or the loss of public employment, but importantly, only if that employment is not at will. If someone is an at-will employee, they generally don't have a protected property interest in continued employment that triggers due process before firing.
That's a key distinction for public employment. Okay, once a protected interest, life, liberty, or property is identified, how do courts determine what specific process is due? It sounds like it can vary quite a bit, from just a notice to a full-blown trial-type hearing.
It absolutely varies, and the Supreme Court established a flexible balancing test in the Matthews v. Eldridge case to determine the amount and type of process due in any given situation. It's not a one-size-fits-all approach. The court weighs three factors.
Okay, the Matthews factors, what are they?
First, the private interest affected how important is the right or interest of the individual being deprived. Is it a minor benefit or something essential like subsistence benefits or parental rights? Second, the risk of erroneous deprivation through the procedures currently used, and the probable value, if any, of additional or substitute procedural safeguards in reducing that risk. Would more procedures like cross-examination or a pre-deprivation hearing actually make a significant difference in getting a more accurate outcome? And third, the government's interest, which includes the function involved and the fiscal and administrative burdens or costs that the additional or substitute procedural requirement would entail. Is it too expensive or cumbersome for the government to provide more process?
So the balancing act, individual interest, risk of error versus value of more process, and government burden.
Precisely. Balancing these three factors determines whether, for example, just a post-deprivation notice and opportunity to appeal is sufficient, or if a full pre-deprivation evidentiary hearing with counsel and cross-examination is required. Generally, at a minimum, an individual whose interest is being deprived is entitled to 1. Reasonable notice of the government's action by an unbiased decision maker, and 2. An opportunity to be heard at a meaningful time and in a meaningful manner. So when you see a question on the bar exam where a person's liberty or property interest is adversely affected by governmental action, always ask. First, is the threatened interest a protected one? And second, if so, what specific process is due based on balancing those Matthews factors?
Substantive due process, Chapter 12.
Chapter 12 introduces substantive due process. Okay, so we just talked about the procedures the government must follow. Now, with substantive due process, we're looking beyond the procedures to the substance of the law itself. Does the law, by its very nature, respect individual freedom and avoid being arbitrary, regardless of how fairly it's applied? That's a great way to put it. Substantive due process is the principle that laws themselves should be reasonable, meaning not arbitrary or capricious, and should not infringe upon fundamental individual freedoms, even if fair procedures are used. It acts as a kind of constitutional backstop, protecting certain fundamental rights, not explicitly listed elsewhere in the Constitution, but understood to be essential to the concept of liberty protected by the Fifth and 14th Amendments. It's about protecting certain interests from governmental infringement altogether, regardless of the procedures used.
So how does this differ from equal protection, which also seems to deal with rights and fairness of laws? This distinction is often a tricky one for students.
This distinction is absolutely crucial for exam purposes, and they love to test it. Substantive due process, SDP, issues typically arise when a law infringes a fundamental right for all persons or a very broad, undifferentiated group. For example, a hypothetical law banning all marriages or all use of contraception would raise an SDP issue because it affects everyone's fundamental right.
Okay, SDP affects everyone. How is EP different?
Equal protection, EP, issues arise when a law treats different classes of persons differently with respect to a right. So, a law banning marriage for only a specific racial group or providing benefits only to men would trigger an EP analysis because it involves a classification. The key difference is whether the law impacts everyone in the same way SDP, or treats different groups differently based on some classification. Sometimes both can apply, but usually one is the more direct fit for the problem.
Got it. And when we analyze these laws under either SDP or EP, the level of scrutiny the court applies is absolutely critical, determining how difficult it will be for the government to justify its action. We saw this a bit with EP already.
Absolutely. The level of scrutiny is outcome determinative in many cases. Under substantive due process, there are two primary standards of review. First, strict scrutiny. This is the highest level of review and applies if a government action infringes a fundamental right protected by substantive due process.
Like the right to marry or privacy.
Like the right to marry, privacy rights related to family and procreation, with some caveats. The right to vote, the right to interstate travel. When strict scrutiny applies, the burden is squarely on the government to prove that the law is the least restrictive means, meaning it's absolutely necessary and narrowly tailored to achieve a compelling government interest. Least restrictive means there's no less burdensome way to achieve the interest, and the law isn't over or under-inclusive. A compelling interest is a necessary or crucial interest, like national security or preserving public health. Laws subjected to strict scrutiny are very rarely upheld. It's usually fatal, in fact.
Fatal in fact. Okay. And if it's not a fundamental right being infringed, what's the default test?
Then the default and far, far more deferential test is rational basis review. This applies if the government action infringes an ordinary right, i.e. not a fundamental one, which covers most economic and social welfare regulations. Here, the burden shifts entirely to the challenger to prove that the law is not rationally related to any conceivable legitimate state interest.
Any conceivable interest.
Any conceivable legitimate interest. The government's stated interest in enacting the law need not be the actual one that motivated it. Any legitimate reason the court can imagine will suffice, even if it's hypothetical. This is an incredibly low bar for the government to clear, and laws reviewed under rational basis scrutiny are almost always upheld. It applies to a huge range of laws, including those related to business regulation, lifestyle choices, taxation, zoning, and things like punitive damages caps.
So what are these fundamental rights specifically protected by substantive due process, the ones that trigger the very tough strict scrutiny standard? Let's break them down.
Okay, there are several core ones that have been recognized over time. First, the right to travel. There is a fundamental right to travel from state to state, to migrate and become a resident of a new state, and to be treated equally once you become a resident. While reasonable short residency requirements might be okay for some benefits like in-state tuition, durational residency requirements that deny newcomers basic necessities of life, or fundamental rights are permitted only if the state can satisfy strict scrutiny. Once a person qualifies as a resident, they generally must be treated like other residents.
And voting rights. That's clearly fundamental. We mentioned it overlaps with EP.
Absolutely. Voting and ballot access are also fundamental under SDP, as well as ET. Every eligible U.S. citizen has a fundamental right to vote. Severe restrictions on voting trigger strict scrutiny under SDP, just as they do under EP when they discriminate. Ordinary, non-discriminatory restrictions usually get rational basis, but laws that significantly burden the right to vote itself face tougher review.
The right to privacy is another huge one, often associated with substantive due process. What specific aspects does that encompass? It seems like a broad category.
The right to privacy is indeed a broad umbrella that covers various fundamental personal decisions, often understood to emanate from the penumbras, or shadows, of several Bill of Rights amendments, or as inherent in the concept of liberty. These specific rights triggering strict scrutiny include the right to marry, the right to procreate, the right to obtain and use contraception, the right of parents to make decisions regarding the care, custody, and control of their children, the right of extended families to live together, the right to refuse unwanted medical treatment, and potentially the right to avoid disclosure of deeply personal information.
Okay, a lot of family and bodily autonomy issues there. What about abortion? That's obviously been a major focus.
Right. Historically, the right to abortion was considered fundamental under privacy, subject to a unique framework. However, the U.S. Supreme Court's decision in Dobbs overturned Roe v. Wade and Planned Parenthood v. Casey, explicitly holding that access to abortion is not a fundamental right deeply rooted in the nation's history and tradition. Therefore, state laws regulating or prohibiting abortion are now generally subject only to the lowest standard of rational basis review. This represents a massive shift, giving states significant authority to restrict or ban abortion that they didn't have before Dobbs.
That's a huge change from the previous framework. And finally, the Second Amendment regarding firearms. How is that interpreted through the lens of substantive due process, or is it separate?
The Second Amendment guarantees an individual's right to possess a firearm, particularly for self-defense in the home, as established in Heller and MacDonald. While the court incorporated this right against the states via the 14th Amendment's Due Process Clause, the standard of review is still developing. The court hasn't explicitly adopted strict scrutiny, but has indicated that regulations are valid only if they are consistent with the nation's historical tradition of firearm regulation. This historical approach seems to be the current framework, rather than applying the typical SDP tiers of scrutiny directly. 3313 Recordy. Chapter 13.
Now let's turn to Chapter 13, Equal Protection. This is where we analyze situations when the government treats different groups or classes of people differently. What level of justification does the government need for such distinctions, and how is this different from substantive due process again?
The Equal Protection Clause of the 14th Amendment is central here, applying directly to states and local governments. Importantly, those same equal protection principles apply to the federal government through the Fifth Amendment's Due Process Clause, a concept sometimes called reverse incorporation. So the analysis is basically the same for state and federal action.
Okay.
The core question is whether governmental classifications treating Group A differently from Group B are permissible. As you noted, while substantive due process asks if a law infringes a fundamental right for everyone, equal protection asks if a law discriminates against a particular group or draws lines between groups in a way that denies equality.
And like substantive due process, there are different standards of review that apply, depending on the nature of the classification being used by the government.
Yeah.
Can you walk us through those again in the EP context?
Exactly. We have the same tiered system of scrutiny, but applied to classifications. First, strict scrutiny applies here when the government classification either substantially burdens a fundamental right, like voting or travel or EP and SEP overlap, or when the government intentionally discriminates based on a suspect class. The classic suspect classes are race, ethnicity, national origin, and, in most state and local contexts, alienage, non-citizen status.
So race-based laws get strict scrutiny.
Yes. And for strict scrutiny, the government has the heavy burden of proving that its classification is the least restrictive means, narrowly tailored, to achieve a compelling governmental interest. Again, this is a very high bar, and laws using suspect classifications rarely survive strict scrutiny.
What about the next level down? Intermediate scrutiny. What classifications trigger that?
That's intermediate scrutiny. This applies when the government intentionally discriminates based on a quasi-suspect class. The main quasi-suspect classes recognized by the court are gender and legitimacy, classifications based on whether a child was born inside or outside of marriage.
Okay, gender and legitimacy get intermediate scrutiny. What's the standard?
Here, the government has the burden of proving that its classification is substantially related to an important governmental interest. This is a middle ground, tougher than rational basis, but less demanding than strict scrutiny. The fit between the law and the goal needs to be pretty good, and the goal needs to be genuinely important.
And the default, the lowest level of scrutiny, is rational basis review, just like in SDP.
That's rational basis review. This applies to all other classifications, basically. Anything that isn't suspect or quasi-suspect and doesn't burden a fundamental right. This covers classifications based on age, disability, wealth, sexual orientation, as of now, and most economic or social regulations. This is the default highly deferential test. The burden shifts to the challenger to prove that the classification is not rationally related to any legitimate governmental interest. As we discussed, this is very easy for the government to pass. Any plausible, non-arbitrary reason will usually suffice.
So for strict or intermediate scrutiny to even apply, there has to be discriminatory intent on the part of the government. Discriminatory impact isn't enough on its own, correct? That seems like a really important threshold.
That's a crucial point for equal protection analysis and a common bar exam trap. To trigger either strict or intermediate scrutiny, there must be discriminatory intent or purpose behind the government's classification. Discriminatory impact alone, meaning a facially neutral law happens to disproportionately affect a particular protected group, is generally not enough to trigger heightened scrutiny. You need to show the government meant to discriminate.
How does one prove that discriminatory intent? That sounds like it could be difficult.
Intent can be shown in a few ways. A law can be facially discriminatory, where the language of the law itself explicitly draws a distinction based on race, gender, etc. For example, only men can be firefighters. In such cases, discriminatory intent is presumed from the face of the law.
Yeah, okay, that's obvious.
Alternatively, a law might be discriminatory in its application. This is where a facially neutral law is applied by government officials in a discriminatory way. For example, a prosecutor using peremptory challenges to strike all black jurors. Here, purposeful discrimination